I would like to share within this 10 minutes, it is of course a selection of some verdicts of the Court of Justice regarding access to justice and how the court sees it in the member states. So what, according to the Court of Justice, are obligations of member states to guarantee access to justice in environmental cases. There are a few aspects which could be discussed in this respect. First, what can be challenged in court? Secondly, by whom it could be challenged, which is the issue of standing. And naturally, the two issues are usually discussed together by court, which means that the court says what could be challenged by whom, under what conditions. And two other issues which I try to touch upon is issue of effective remedies, in particular injunctive relief, and also the scope of judicial review, which is what the court should examine during in a given case. The first, what and by whom, is starting. I would like to start from the older verdicts and those related to Article 9.2 of the Aarhus Conventions. The first one is the older case. It's Kreifeld, the case regarding environmental impact assessment, as you probably know. And here the court said that members of the public concerned whose participation rights were violated during the proceedings, meaning those who were not entitled to participate, contrary to the EIA directive, those persons are entitled to challenge decisions issued, the decision authorizing a project, which is this development consent under the EIA directive. Then building upon this verdict and many others probably is the second case where this famous Wilk 2, where the court said that environmental NGOs are also entitled to challenge decisions authorizing activity where this case was already mentioned by Jurek. Here, firstly, the court said that cases concerning activities affecting Natura 2000 sites are subject to Article 6.1b of the Aarhus Conventions, and as such, they should be subject to public participation, and consequently that they should be subject to access to justice according to the provisions of Article 9.2 of the Aarhus Convention and so on. So, and this case was brought by environmental NGOs, by Slovak NGO. So the court said, yes, you are entitled to challenge this decision. And in the commission notice, it was a comment on this, the notice, you know, on access to justice. There was a comment on this, that this verdict may also apply to other decisions other than Natura 2000 or Habitats Directive issues, as this also may apply to decisions in other sectors of environmental law, like, for example, water protection or waste issues and so on. Then in two cases regarding, there were two cases regarding negative EIA screening decisions, which means that if the authority decides that in a given case EIA is not needed, not required, the same person who, according to the EIA directive, would be entitled to challenge the development consent, are also entitled to challenge the negative screening decision. And it is not always guaranteed by, it is maybe not very directly said in the EIA directive, but it is an interpretation of the Court of Justice. Then continuing on what could be challenged and by whom is now we have some cases which are based or which might be referred to Article 9.3 of the Aarhus Convention. First is the famous Slovak beers case, where Slovak NGO wanted to challenge a decision authorizing beer hunting, which is a decision granting a derogation to the general protection of some species like brown bears. And in this case, the court said that although Article 9.3 is not directly applicable in the member states, it is up to the national court to interpret the national law in order to ensure the broad access to justice, and the court referred here to the rules of the Article 9.3 of the Aarhus Convention. The exact wording used by the court is that it refers to decision taken following administrative proceedings likely to be contrary to European Union environmental law, which also might be interpreted that it goes further than only this species protection under Habitats Directive, but also might refer also to other aspects of environmental EU law. The next verdict, where although in this verdict the court did not directly refer to, as far as I remember, they did not directly refer to Article 9.3. It is also the same scope of issues, and it is quite important verdict, as in this case the court confirmed that a private person whose health might be concerned by activity or the lack of activity of public authorities are entitled to challenge those acts or omissions to the court. And in this case, as you probably know, it was about the air protection plan regarding in Munich, regarding the local law was not sufficient to ensure that health of people living in this area is protected. So it was given to the court, clearly confirmed that it should be ensured. And also regarding, also in the Commission notice, it was mentioned that this verdict might be relevant also for other sectors of environmental law. Similar approach was given in another verdict, but here the court said that also environmental NGOs are entitled to challenge a failure by authorities to establish national measures. In this case, it was more than only local, but because it was about national emission ceilings, also a case regarding air protection. And similar approach regarding plants was also presented in this case regarding client earth. So it is quite important because it concerns more general instruments like plans or programs, and not only authorization of individual projects. Also in this verdict, Protect Nature, the court said that environmental NGO are entitled to challenge decisions regarding Water Framework Directive. It was about a case about a project which was likely to affect the status of bodies of water, which would be contrary to Article 4 of the Water Framework Directive. So court also granted the standing to environmental NGO, and also referred here directly to Article 9.3 of the Convention. Another issue, which is injunctive relief, it was clearly confirmed in the Krijan case that it was in this case the court referred to integrated permit issued at that time under the IPPC directive. Now it would be Industrial Emission Directive. And the court confirmed that members of the public concerned do have not only a right to challenge the permit, but also to ask the court for injunctive for temporary suspension of the this permit, which is subject to their case. Then the last issue quickly is only some aspects of the scope of review, because it could be discussed in other aspects as well. But one case which I would like to mention here was this case is relevant for those countries which base their right to their standing on the impairment of rights, because as you know, it's either having an interest or maintaining impairment of rights, and as in Germany it's impairment of rights. The court said that it is okay to give legal standing only for individuals whose rights are impaired, and consequently that the court may examine only those provisions which are the entitled individual which are challenged by the given individual. So if a person challenges a decision because his or her specific right is violated here, the court may limit the examination only to this aspect of case, and not to examine other aspects or other provision which might be violated in this case. But then there was another verdict which said that it is while this rule applies to individuals, it does not apply to environmental NGO, as they do not need to prove that their interests have been violated in a given, or their right was violated in a given case. So I think it is all for the 10 minutes. Of course, as I said, it's a selection only. So thank you. I think 10 minutes passed. So thank you for this.
Yeah, thank you very much, Magda, for this overview. And I think, yeah, you mentioned also a couple of German cases, and I think Germany had a lot of, there was a lot of positive impact of the Aarhus Convention, and also of the jurisprudence of the Court of Justice in access to justice, because as I said in the beginning, there was not very much before Aarhus Convention entered into force. But it's somehow also strange that the court is very progressive, the European Court of Justice, very progressive in giving standing rights for NGOs under the Aarhus Convention for the member states. But when it comes to the EU level itself, then the court is not at all progressive, but much more reluctant. And so I think it's very important now to hear the last speech for today from Anais Berthier, who will present us something about the EU level. And I propose for the participants just to, if you have any remarks or questions, to collect it for the discussion afterwards. So I would like to give the floor to Anais, and we said, just a second, I will show the presentation, okay?
Okay, right, thank you.
And so I have to share the screen.
Great.
Okay.
Thanks. Thanks a lot. Hi, everyone. So I'm Anais Berthier from Client Earth. And so with the short term that has been allocated, so with only 10 minutes, I'll give you a very brief overview of the situation about legal standing before the EU courts. Next slide, please. So as I'm sure you all know, there are some really significant limitations in relation to the legal standing rights for non-privileged applicants before the EU courts, so which includes individuals and also NGOs. Limitations both in the jurisprudence of the EU courts, but also in the Aarhus regulation, so at these two levels. So of course, I won't go into all the details, but as you know, so there is the famous Plowman test, in which the EU courts have interpreted the criteria that applicants need to fulfill to have legal standing before the court, so to be either directly and individually concerned by the act they want to challenge before the court, or to be only directly concerned if they challenge a regulatory act which do not entail any implementing measures. And the EU courts have adopted an interpretation in the Plowman test in 1963 and haven't changed since then. So have kept the same interpretation of the individual concern criteria for the last 6 decades. And this interpretation is very, very, very restrictive and very narrow, and has led to the situation we are in today that prevents any individual or any NGO to have legal standing before the EU courts and to challenge any decisions adopted by European institutions, agencies, and bodies. The other legal route that NGOs and individuals and non-privileged applicants can take to challenge decisions of the European institutions before the EU courts is the Aarhus regulation that provides the rights only to environmental NGOs to challenge certain acts adopted by the European institutions, first through an administrative process. So the NGO has the right to ask the European institution to review one of its decisions through a request for internal review, and then to challenge the reply of the European institution to that request before the court. However, the issue here is that the definition of the acts that NGOs may challenge is very, very narrow. And has been found actually in breach by the Aarhus Compliance Committee with the Aarhus Convention. And so the main issues is that the administrative acts that NGOs can challenge are defined as acts of individual scope adopted under environmental law and must have external and legally binding effects. But external is, according to us, an issue. The other issue is that there are exemptions as well, so that exempts certain other decisions adopted by the European institutions from the regulation, and I'll go back to that a bit later on. And also that NGOs can only challenge the reply of the European institutions to the internal review request before the court, and not the actual decision that we would like to be able to challenge in the first place. Next slide, please. That doesn't show properly. I don't know why. Okay, so what we've done at Client Earth is that we've made a communication in 2009, and very long story short, the Compliance Committee adopted its final findings in 2017. Founding the EU in violation of Article 9.3 and 9.4 of the Aarhus Convention. So both the jurisprudence of the court and the Aarhus regulation. So the Compliance Committee stated that it was really clear that Article 263, paragraph 4 of the treaty could be interpreted otherwise, so as to provide standing to qualified individuals and NGOs. and that neither the jurisprudence of the court nor the Irish regulation provided access to justice to the members of the public for the purpose of the convention, and recommended, notably, so it adopted a series of recommendations, but one of the recommendations is to amend the Irish regulation, but also for the court to interpret the treaty provision otherwise. So no need to amend the treaty to improve the situation and to ensure members of the public have legal standing before the court. The court could very well make its interpretation of the treaty evolved, since we are in 2020, not in the situation, the society has evolved since 1963. And so, next slide, please. So briefly, I won't go into everything that happened after the adoption of the findings by the Irish Committee, although it was very, very interesting from a European institutional perspective. The European Commission was very strongly opposed to these findings and actually wanted to oppose to the endorsement of these findings at the MOP, at the meeting of the parties. So there has been an interesting dialogue, let's put it that way, between the Commission and the Council, which for once was more on our side and tried to reach a compromise. And the result was that no decision has been adopted at the MOP, first time ever that it happened. So fortunately, the findings haven't been rejected as the European Commission wanted, but the compromise reached by the Council to take note of the findings but not endorsing them was not accepted because of the NGOs, because of Switzerland, Norway, and the chair of the MOP and everybody. So we avoided the worst, but it was a very negative image that the EU gave of itself in an international forum, and a very negative precedent that they have set. Going back to Brussels, the Council decided to act and for the first time ever adopted a decision on the basis of Article 241 of the treaty, asking in environmental matter, I don't know if I mentioned that, asking the European Commission to act and so to adopt a study and to assess the best ways to bring about compliance with the Aarhus Convention and to comply with the findings of the Compliance Committee and to revise the Aarhus regulation if appropriate. The Commission respected that request and hired the consultancy Milieu, which did a really long report assessing all the different possibilities and options and concluded that the best option for the Commission to act was to revise the Aarhus regulation. Next slide, please. And so the European Commission first committed in the communication on the new Green Deal to consider revising the Aarhus regulation to improve access to administrative and judicial reviews for citizens and NGOs, and then adopted a roadmap last March. And the Commission has identified two possible ways to revise the Aarhus regulation. The first issue they have identified is the criteria that the Act has to be of individual scope, which is right because more than half of the requests for internal review are rejected by the European institutions for not being of individual scope. So the European Commission would propose to get rid of the individual scope criteria to broaden the scope of review to include non-legislative regulatory acts, and then would reflect the change to the TFEU that has been brought by the Lisbon Treaty. Second amendment would be to specify that the administrative acts and omission covered by the internal review mechanism are those that contravene provisions of environmental law and not those which are adopted under environmental law, like it is written in the regulation today. So to align the regulation with the convention. And last proposal in the roadmap would be to extend the time for procedural steps for NGOs to make their internal review request, but also to extend the time the European institutions have to reply to the request for internal review. Next slide, please. And so we, of course, welcome that decision from the European Commission to revise the ARIS regulation. It's taken a very, very, very long time, but we welcome it. And we agree with the proposed changes, but not totally. So the European Commission, according to us, doesn't go far enough. And we are concerned that the fact that the European Commission will propose to align the wording of the regulation with the wording of the treaty, and so to only allow NGOs to challenge non-legislative regulatory acts which do not entail implementing measures at national level. And so that would be a new restriction, a new limitation that wouldn't be in line with the ARIS Convention, because of course it's nowhere mentioned such a limitation in the ARIS Convention. The ARIS Convention only mentions acts and omissions. That would lead to issues of interpretation, not only by the European institution replying to the internal review request to know whether the act will entail implementing measure or not. Then the NGOs would challenge the decisions to get a ruling from the court on whether the act entail implementing measures or not. And so that would lead to a lot of confusion and lack of legal certainty, and would again limit unduly the right of NGOs to challenge decisions of European institutions. We also think that the European Commission should have looked at the exemptions that are proposed in the ARIS regulation, and notably the one that exempts decisions that are adopted by European institutions in their administrative review body's capacity. The Compliance Committee has also agreed that that's not in line with the Convention. And we think that, for example, the state aid decisions adopted by the European Commission should be challengeable before the court, and that there shouldn't be any exemption to protect the decision adopted by the European Commission allowing state aid. We should also have the possibility to challenge the procedural and substantial legality of the decisions, and not only the reply to the internal review request. And finally, we would like the European Commission to also address the fact that the cost before the court, the EU courts, should not be prohibitively expensive, because there is a recent trend to ask from the court to ask NGOs to pay the cost, notably of interveners. And so that happened in 2 cases, that an NGO had to pay the cost of interveners. In some cases, there were like around 10 companies intervening. And in another one, another NGO has been condemned to pay around 2,400, I think, euros, which can be a deterrent for NGOs to go to court. So we would like to see something about the cost not being prohibitively expensive. Thank you. I think I've spoken a bit more than 10 minutes.